The courtroom goes silent the moment you walk in. Not because you're late. You're never late. You walk in at exactly 9:02 every morning, 2 minutes past the hour, just enough to make everyone feel it. The bailiff calls order. 200 eyes find you. A defense attorney straightens his tie. A prosecutor stops mid-sentence. A man in the defendant's box, mid-30s, scared, wearing a suit his wife probably picked out, looks at you like you might be God. You sit down. You open a folder you've already read, and somewhere in the back of your mind, behind the composure and the robe and the 31 years of legal precedent, you think about the envelope that was slipped into your car door 3 nights ago. Cream-colored, thick. You didn't open it in the parking garage. You waited until you got home, poured 2 fingers of scotch, and sat alone in your study with the curtains drawn. $140,000, untraceable, and a single typed sentence, the Alcott verdict. We trust your judgment. You set the glass down. You didn't sleep that night, but you are here now, robe pressed, gavel in reach, face like carved stone, and the Alcott verdict begins. You didn't start this way. That's the thing no one tells you about corruption. It doesn't arrive like a villain at your door. It seeps in through the cracks of a life that was, for a very long time, genuinely good. You grew up in a row house in Baltimore, or a council estate in Birmingham, or a duplex in Hamilton, Ontario. The specifics don't matter. What matters is that your mother ironed your school shirt every morning, that your father worked a job that paid him less than he deserved, and that you were the kind of kid who read everything: encyclopedias, paperback thrillers, the newspaper. By 14, you understood that the law was the spine of civilization, the invisible architecture that separated order from chaos. You went to a state school on a scholarship. You graduated near the top. You clerked for a federal appellate judge who told you on your last day that you had one of the sharpest legal minds he'd seen in a decade. You believed him. You had reason to. You spent 12 years as a litigator, civil rights cases, wrongful imprisonment appeals, the kind of work that wins awards but not salaries. You turned down 2 firm offers that would have made you rich. You believed in the institution. You believed the courtroom was the one place in society where power and poverty sat at the same table, and the rules were the same for both. Then you got the appointment. High court judge, federal circuit, your name in the newspaper, your mother crying on the phone, a ceremony with handshakes and photographs, and a feeling in your chest like everything had finally arranged itself into the shape it was always supposed to take. That was 19 years ago. And somewhere between then and now, you changed. Not all at once, never all at once. It started with a favor, a small one, a ruling on a zoning dispute that, when you read the case objectively, could have gone either way. A man named Gerald Parrish, old money, easy smile, the kind of man who knows what table to book at what restaurant, took you to dinner, not to bribe you, just to talk, to remind you that you were part of a community, that the people who built this city had interests, and those interests and the law were, more often than not, pointing in the same direction. You ruled in his favor. It was defensible, technically correct. You told yourself that. 6 months later, Gerald introduced you to someone with more money and fewer manners, who didn't bother with dinner and just asked directly, what would it take? You said no. You said it cleanly and you meant it, but you didn't report it. That was the real moment, not the envelope, not the Alcott case. The real moment was when you decided that what had been offered to you was something you could quietly step around, rather than something you had to demolish. You left a door unlocked, and eventually, someone walked through it. Here is what your days actually look like now that you're in it. The money never touches your hands directly. You learned that early. There's a man, you think of him only as Marcus, though that's almost certainly not his name, who manages what he calls appreciation transfers, small businesses you nominally consult for, a real estate LLC that deposits quarterly dividends into an account registered to your brother-in-law in Phoenix, a speaking fee from a private legal conference in the Cayman Islands you attended once, gave a 40-minute talk on procedural reform, and have been paid for 11 times since. The IRS sees income, legitimate, documented, boring income, every bracket filled, every form filed. Your accountant is very good and, more importantly, very quiet. The cases, when they come, are never crude. Nobody calls you. Nobody meets you in parking garages in a trench coat. What happens is this. A case is assigned to your docket, sometimes through normal rotation, sometimes through what you suspect is gentle manipulation of the scheduling system by clerks you will never meet. And then, within a week, you receive a communication. Sometimes it's through Marcus, sometimes it's a brief message through a private legal discussion forum that on its surface looks like a routine exchange between colleagues. Once it was handwritten notes tucked inside a legal brief filed by a white shoe firm whose partners have never once appeared in your court in person. The message is always surgical. It doesn't tell you how to rule. It tells you what outcome matters. The mechanism, the legal logic, the cited precedent, the crafted language, that's left to you. Because the people paying you understand that the value isn't in the verdict. The value is in the verdict being unappealable, bulletproof, written by a judge with a 31-year record of integrity. You are not just being bought, you are being rented for your credibility. And here is the part that keeps you up at night when you allow yourself to think about it. You are very good at it. You know the law well enough to find the seam in almost any case, the place where a reasonable interpretation and a favorable interpretation overlap. You write your opinions in careful, measured language. You cite precedent. You acknowledge counterarguments and dismiss them with precision. Law clerks who work for you for a year graduate believing they've worked for one of the most rigorous judicial minds on the circuit. 2 of your former clerks have published papers praising your methodology. The system that was built to catch people like you cannot catch you because you were built by the system. The Alcott case is a corporate negligence suit. A pharmaceutical company, you won't name them, internally you refer to them only as the client, is being sued by a class of plaintiffs, nearly 400 families, whose children were harmed by a drug that the company knew, according to internal emails obtained in discovery, carried a higher risk profile than its public filings. The envelope contained $140,000. The client's annual revenue is $11 billion. You run the math without meaning to. The motion before you today is a summary judgment request filed by the defense, a procedural move to have the case dismissed before it reaches a jury, on the grounds that the discovery evidence was improperly obtained. It's a thin argument. You've read it 4 times and you know it's thin. Dempsey will demolish it in oral argument. Every clerk in your office agrees it should be denied. But if you grant it, and you can grant it, you've written the 15-page opinion already, drafted at 2 a.m. in your study, careful, sourced, technically defensible. The case dies. No jury, no damages, no verdict. 400 families go home with nothing if you grant the motion. And somewhere, a transfer is initiated. You sit on the bench and you watch Saoirse Dempsey stand up. She's 42. She has the kind of posture that comes from spending rooms where people assume you don't belong. She begins her argument without preamble, and within 90 seconds, you understand that she is aware the motion is a trap. She's not just opposing it, she's methodically dismantling each pillar of the defense's logic, citing 3 circuit court rulings you know well, and 1 district court opinion from 2019 that you had forgotten, and that, if you're being honest, strengthens her position significantly. You watch her. You think about the 400 families. You think about the man in Phoenix with the account. You think about your mother ironing your school shirt. You think about the judge who told you that you had one of the sharpest legal minds he'd seen in a decade. You look down at the bench. You look up at Saoirse Dempsey. You say, "Counsel, please proceed." And you keep your face completely still. The thing about living inside a corruption you've built carefully is that it doesn't feel like corruption from the inside. It feels like management. You tell yourself the story that most people in your position tell themselves, which is that the cases you've bent never came to be clean to begin with, that the law is already a system tilted towards money and access, that you are simply operating within a machine that was cruciated before you arrived, that the 400 families in the Alcott case would receive, even if Dempsey won, a settlement that the company's insurance arm would pay out of a pre-allocated litigation fund, while no executive face any consequences. You tell yourself that the world is not changed by verdicts. You tell yourself you've also ruled honestly in hundreds of cases, which is true. You tell yourself your honest rulings, your published opinions, your contributions to procedural law have protected more people than you've harmed. You do not examine this math too closely, but the math has a way of surfacing anyway. There is a woman, you saw her in the corridor outside the courtroom this morning, sitting on a bench with her hands in her lap, wearing a coat that was too light for the weather.
She has a daughter, you know this from the case files. The daughter is 9. The drug that harmed her left her with a seizure disorder that requires daily management, 2 specialist appointments a month, a medication regimen that costs her mother, who works 2 jobs, roughly $800 out of pocket every quarter. You know her name. It's in the file. You don't think about it. You are very good at not thinking about it. But here, in the recess, alone in your chambers with the door closed and your robe hanging on the hook, you sit at your desk and you put your hands flat on the wood and you just breathe. For a moment, you are not a judge or bribed official or a construct of 30 years of careful reputation building. You are just a person with a decision in front of them. And you know in the part of yourself that you have worked very hard to keep small and quiet, that what you are about to do is wrong. Not legally wrong. That's the cage you built. Legally, you can justify it. You already have. Morally wrong, plainly, irreducibly. You stand up. You put your robe back on. You walk back into the courtroom. The room stands when you enter. You sit. You look at the motion on the desk in front of you. Defense counsel is confident, the particular stillness of a man who already knows the result. Dempsey is watching you with an expression you can't fully read. Professional, alert, somewhere beneath the surface of it, hoping. You open your mouth, and here is where the story stops being yours. Because this is the moment, the exact moment that every corrupt system depends on. Not the bribes, not the offshore accounts, not the carefully written opinions. It depends on this, the moment where one person, alone, with every exit sealed and every justification loaded, decides what kind of person they are going to be for the next 30 seconds. The money is already transferred if you rule in the defense's favor. The account in Phoenix, the quarterly dividend, the speaking fee from the conference you will attend in March. The case dies if you grant the motion. 400 families go home with nothing if you grant the motion. A 9-year-old girl's mother works 2 jobs and pays $800 a quarter if you grant the motion. Gerald Parrish, wherever he is, smiles his easy smile if you grant the motion. And you? You go home. You pour 2 fingers of scotch. You sit in the study with the curtains drawn, and you carry it, the way you've carried all of them, in the sealed room at the center of yourself where you keep the things you will not look at directly. Or you look up. You look at Dempsey. You look at the man in the defendant's box, not Alcott, never Alcott himself, just a senior VP who was told to show up. And you remember what a courtroom is supposed to be. You clear your throat. The court has reviewed the motion for summary judgment, you say, and the defense's argument regarding the discovery process. Pause. The motion is... The room holds its breath, and the camera cuts. You just lived 1 minute inside a decision that thousands of real people never get to see. The hallways behind verdicts, the math behind justice, the gap between what the law says and what the law does. If this hit different, drop a comment. Tell me, did he grant the motion or deny it?
What would you have done? The best answer gets pinned. Subscribe to Street Level Stories if you want to keep living inside the rooms where real power moves. New POV every week. The mob, the agency, the courtroom, the empire, all of it from the inside out. And watch this next, because the story doesn't end in the courtroom. It never does.